Yeah.
Please be seated. We're here for oral argument on Goldwater versus Phoenix et al. Our number CV-25-0033. A couple of things before we start. First, Justice Marilena Cruz has recused herself in this matter, so we have former Chief Justice Birch joining us. Thank you very much for filling in. Always a pleasure to have her back. And of course, counsel's experience, you know you have 20 minutes each. There's a clock at the podium for that purpose, and you may use whichever time you wish for rebuttal, but please keep your time yourself. Please begin.
Thank you. Good morning. May it please the court. Parker Jackson on behalf of Appellant Goldwater Institute. Per the court's order, I'll be sharing approximately 5 minutes with counsel for the amici, and with the court's permission, I also intend to reserve about 3 minutes for rebuttal. Self-interested speculation alone cannot be sufficient to justify withholding public records under the so-called best interest of the state exception to public records disclosure. Arizona courts rightly scrutinize any purported justifications for the non-disclosure of public records because Arizona law strongly presumes in favor of disclosure, as this court held in Carlson and subsequent cases. As the court noted in the Scottsdale Unified versus KPNX broadcasting case, the purpose of the public records law is to open agency action to the light of public scrutiny. The public records law exists to allow citizens to be informed about what their government is up to. Not only does that mean that de novo review is appropriate, as this court expressly stated in Cox and Scottsdale Unified and London, but it also means that when a party seeks non-disclosure, most often that's a government body or a records custodian, and they assert a common law exception to disclosure, especially the best interest exception, they must be able to provide evidence establishing a probability that specific material harm will result in disclosure, as this court held in Mitchell. In other words, 4 aspects of that standard must be.
Didn't Judge Viola, she found probability on page 9 of her under advisement ruling, didn't she, Counsel?
I don't think that's correct. So the way, if I remember right, that the trial court phrased it is that I think she said there's a potential for harm that overcomes. That would be somewhat like saying in the criminal context that there's a preponderance of the evidence that's sufficient to convict when the standard is much higher than that.
In her analysis, she outlines the test in Mitchell, the probability of specific material harm must be shown, and she cites the Mitchell.
Yeah, that's correct, Justice Bean. And our position on that is that citing the standard and applying the standard are 2 different things. There were no factual findings of probability made by the trial court. And if you examine the record, which we encourage this court to do in its own de novo review, nothing in the witness's testimony speaks to probability. It speaks to potential, possibility. We hear a lot of words: could, should, may. Nothing that establishes a likelihood or probability. In the end, as this court has said, really means more likely than not.
So likelihood might be a better better term than probability if we were to refine the Mitchell test.
Yes, that would be fair. And that's what our reading of Mitchell and subsequent cases says is likelihood, more likely than not.
Does Mitchell set forth an elemental test? It seems, as you argue, that you have to establish each of the 4 factors essentially as an element. Is that consistent with a balancing test?
I think it is consistent for 2 reasons. So one, the text of Mitchell lays out those terms. I mean, we're obviously extracting these prongs from the text of Mitchell. The balancing test is designed to weigh interests. So what we're really trying to test with this is the cities here, the cities or the party seeking non-disclosure, is that interest strong enough to be considered valid and outweigh the public's interest in disclosure? And what Mitchell provides us is kind of this framework for how do we determine whether these interests are sufficient. Probable, specific, material, and resulting from disclosure. We think all of those are important and required, and we think the subsequent case law supports that. I mean, Mitchell, as we've laid out in our briefing, is cited and relied upon in something like somewhere between half a dozen and a dozen Court of Appeals and Arizona Supreme Court cases. So we don't think there's anything that has ever watered down or gotten rid of those elements of the Mitchell standard.
Why isn't that satisfied here, at least in part? I mean, the way I view this is the contract, the MOU has completed. It's run its course. It's done. So I'd rather look at this for pre-final MOU and post-MOU. In the pre-section, when they're still negotiating, doing all that, why haven't they made that showing when they've tried to limit to very few people who are actually negotiating? And I thought at least made some pretty good points about when you start having the public into the mix and politicians into the mix, it really makes it difficult to negotiate. So why isn't that sufficient showing of harm, at least while negotiations are ongoing, not to turn over those documents? And I'll tell you, I kind of analogize it, since you gave an analogy to criminal, to in a criminal investigation. It's an investigation statement could mess things up if you let documents out. So why isn't that the case here?
Sure. So there are a couple things there. So I think part of what you're asking is, how can we prove, how can we establish that there's this harm? What the court has said in the Board of Regents case and other cases is that one way of doing that is by showing prior instances of harm. That wasn't done here. Another way is by providing expert testimony. That was only done on Goldwater's side, not on the city's side. And then really important here is, as this court has said since Matthews, the court has to tie these assertions to specific records and sometimes to specific portions of records. That requires in-camera inspection. There was no in-camera inspection here. The trial court never looked at the records. The Court of Appeals never looked at the records. And so we don't really know, as you said, we're talking about MOUs. And the Court of Appeals observed that these aren't wholly new documents. These are documents that essentially get redlined.
Well, and that I wondered try to think, what is this going to look like for a trial judge? To go back to do an in-camera review, it's one thing for privacy, for confidentiality. You can get out there and redact social security numbers or private information. You can recognize it. You're talking here about the best interests within a negotiation while the negotiation is ongoing. How is the trial judge, practically speaking, to know what would be in the best interest of the city or not in looking at these, probably voluminous documents going back and forth?
So as a factual matter, we're talking about roughly 50 documents. I think 54.
In the 50 documents.
Yeah. So it's not we're not quite as voluminous as maybe in other cases. I think what the court has said in Matthews and a variety of subsequent cases is that it has to be done case by case. It can't just be done across the board. There's no blanket or sweeping exceptions. So we start from that premise. And then what Carlson says is that this practical alternative to complete denial of access is redaction. And so a trial court, when doing an in-camera inspection, could look at a particular proposal and say, is this something that is going to damage the city if it's out to the public? One example that was given in the trial court of it maybe a specific proposal that could come up in these types of negotiations, aside from wages and benefits, is since we're talking about police records, one of the witnesses talked about, they might ask for more bulletproof vests, for example. And we think that in and of itself probably isn't harmful to the public interest for people to know that. If it got as specific as maybe the type of bulletproof vest where it was going to present a legitimate risk to public safety, if the public knew like what brand of vest somebody was wearing, and that's something that is very fact specific and that a trial court is well positioned to determine on a case-by-case basis.
Are they though? I mean, how is I guess I'm really asking at a granular level, how is the trial court supposed to know that they see a specific type of bulletproof vest, one's okay to release and one's not okay to release? I take it that, the parties aren't going to be arguing in their public record, don't tell them about the bulletproof vest because then it's out. So how will it work?
So I think if there's questions as to specific proposals, the gaps can be filled by expert testimony. That's kind of what happened in Hodai. They brought in an agent, in that case, an FBI agent that was intimately familiar with the particular technology that was at issue there. The city didn't attempt to offer any expert testimony here. And just on the in-camera inspection piece, the counsel in the prior case mentioned that courts can make that determination whether to have an in-camera inspection independently. We think that's true, but we also think that it's the city's burden. If there is this question of whether there's going to be specific probable material harm, that they have the onus is on them to show the trial judge what harm will result from the release of specific proposals. And that gets us kind of this causation piece too, because if the harm exists absent disclosure or regardless of disclosure, then disclosure can't cause that harm. That's really important here because the type of broad general interests that they've asserted here are about the politicization of the negotiation process. The expert witness for Goldwater testified that this process is inherently political.
Well, the U.S. Supreme Court said that in Janus, didn't it?
Sure, yeah. I mean, we're talking about these, anytime we're spending public money, which this court has observed in other cases, when we're talking about the city's most important and largest line item of their budget, I mean, there's just this public interest that's really weighty here.
Why is it weighty, though, before the MOU is finalized? I completely understand why afterwards, fine, it's done. We should look at all the negotiations that went on. But why before? Why it's going on?
It's an excellent question, and it's actually a question that I know my colleague is going to address. So I'm going to take that opportunity to step aside and let her take 5 minutes.
Thank you.
Lauren Bial with ACLU of Arizona on behalf of Poder in Action. In public records law, the best interests of the state includes the best interests of the people. The lower court failed to truly consider how the withholding of the draft negotiation documents would impact the people of Phoenix and the people of our state. Rather, the courts below allowed the city to privilege its own interest in avoiding politicization, pressure, impasse, and collusion. The analysis below essentially equated the public interest with the functioning of bureaucracy and gave almost no weight to how the withholding of police union negotiation documents would impact the people who are policed.
Counsel, can I ask you a quick question? Because you've mentioned that the interests of the people can also, or should also be considered
Yes.
as part of the best interest of the state. But the city in this case made the claim that by at least keeping confidential the MOUs, the back and forth during the blackout period, with respect to the MOUs that were supposed to be presented by the bargaining unit to begin with, and the city's response aside for the moment, just focus on the blackout period. Why isn't it unreasonable? Why isn't it a legitimate interest, one that could balance against disclosure, to say, well, look, if we're able to negotiate confidentially, we're able to save taxpayers money by limiting what might be some of the demands of bargaining units?
Certainly, it's a legitimate interest, it's just not the only one. And it may be that taxpayer money is ultimately saved, but the taxpayers are also not able to know what is going back and forth between the city and the plea in that discussion. So, and there's another point too, Your Honor.
Let me touch on that real quick, though,
Go ahead.
because if the negotiators are aware that those documents will be made public, isn't there some measure of accountability there that the public will get to see what their work was, admittedly not in the middle of it, but at least afterwards, so their work could be graded after the fact?
They will get to see the final changes, Your Honor, but they won't be able to see the directions that each change came from. And you're talking about 54 different proposals going back and forth. So what these draft documents really tell the public is what their government was willing to negotiate away. And that is really at the heart of public records law, the purpose of which is to tell the public what their government is up to. So the back and forth has value separate and apart from the final product. And this was testified to at the trial court level. Isabel Garcia from Poder and Actions said that these draft negotiations have value because they tell the public how much power the plea is exercising over the city in these back and forth negotiations. And I should also say, the plea and the city is empowered to talk as much as they want confidentially, as long as it's not enshrined in a red line document. So it's not that they can't have confidential conversations and back and forth that the public ultimately may never be aware of.
Is there anything in the MOU or in the city code which prevents plea from simply turning over all of these documents to anyone that they want to?
I'm not aware of that, Your Honor, but there is a provision in the city code that says the city is supposed to make these documents public, which was violated in this case. And I think that goes to a point in the public interest as well. Isn't there public interest in following the city code?
Well, I guess my point was if there's nothing that prevents plea from turning over the documents, how important is it that these remain confidential to the city?
Well, I guess it's not plea's obligation to turn them over. It's the city's, you know. And I think here what you have really is the city's fear of labor unrest. And it's a speculative one at that, as my colleague mentioned. The court should have balanced those fears with the public interest in police oversight and accountability. The lower courts were very dismissive of the public interest value of those documents as draft, but as I said, they have separate value from the final product. In this case, these potential harms of impasse, politicization, pressure, they're really different from the harms that the courts weighed in Hodai and in Keegan and in Arizona Board of Regents. You know, in Keegan, the court found that the public interest supported non-disclosure of these anchor questions on standardized tests because releasing these anchor questions would undermine the state's ability to evaluate fairness of a test that is required for students to graduate from high school. And then in Hodai, you have this balance of the public interest in knowing about law enforcement technology with the potential for a bad actor to employ countermeasures against this police technology. So you have a real threat to ongoing law enforcement investigations and potentially in the future undermining this technology and producing counter technology. And
this question may better go to Mr. Jackson on rebuttal, but as I look at the questions presented, they are standard of review questions, it seems to me, and not we are not directly, and correct me if I'm wrong, we're not directly asked whether negotiations should be shielded. We're not asked to make that balancing determination. But if we rule that the correct standard is de novo review, is there anything left to this case now that the MOU is done? Is there a remand type situation, or are we simply done once we've answered the questions that were presented?
To my understanding, Your Honor, the draft MOUs have not been released, and I think that those things still have value, even though the time has long passed, because it does inform the public about what their government is willing to negotiate away on their behalf. And this is a publicly funded job that is completely paid for by taxpayers, and it is the sector where government employees are empowered to use force, including deadly force, against the public. It's hard to imagine how the public interest could be more implicated than in these kind of negotiations. And I agree with you that de novo is up for review. Finally, as I was saying in Arizona Board of Regents, in that case, this court balanced the public interest in finding the most qualified candidate for ASU president against the public's right to know about the selection process. So nowhere in any of these line of cases did the court find that the public interest was coterminous with the functioning of one agency, whether it was in efficiency or, keeping people from being upset about a labor process. PLEA is a very large, very powerful public sector union. It uses its power to negotiate wages, but it also uses its power to do things like negotiate what happens when police misconduct or abuse occurs. So to omit any of that consideration from what public interest means reflects a really fundamental misunderstanding of public records law. In Keegan, the court wrote that the state fails to recognize the significant interests arrayed against its asserted interest of expense and convenience. The same has occurred here, and Arizona case law does not support that a public office can hide behind mere expense and inconvenience to invoke the public interest exception to disclosure. And if there's no questions, I'll hand my time to my colleague.
Thank you. Hey, Mr. Palladini.
Good morning. May it please court, John Palladini for the City of Phoenix defendants or respondents in this case. The petitioner's argument is really two-pronged. First is the use of the word potential by the trial court. But as I think Justice Bean pointed out, the trial court stated the test, the probability of material harm, and then went on to use the word potential.
And while you're thinking about that, counsel, she also used speculative.
Well, but speculative is okay because that's
for the cases that the court cited.
Yes,
because I looked at those three cases, and there's only one that really talks about speculative, and that last one actually referred to speculation as cutting against the defendant.
But Your Honor, all of the cases that are cited in this all use the word could or would when it talks about the harms that are argued. Because all of the adages, the cow's out of the barn, the cat's out of the bag, you can't unring the bell. You can't allow the documents to be released and then point to the harm and then try and unrelease those. That's the whole point of this. It's all reasonable prediction. So I'm not sure speculative is necessarily the right word, but it's all reasonable prediction. And so when the trial court used the word potential, that's not an unprecedented or unusual or novel concept. Two of the cases that are cited, Hodai talks about uses potential injury here is specific when it talked about withholding those documents. So it uses the word potential, as did the KPNX Yuma County case, says that that someone, and that one, by the way, is sort of layers of what could happen if the body cam video were released. Someone could or might use the information to cause potential harm to life in law enforcement. So when you're looking at the harms, it's not that they had to have happened in the past, although the First Board of Regents case does look to past history, for instance, to predict future behavior or future occurrences, but that's what happened in our case too. The negotiator for the city of Phoenix, Perkaiser, testified about his own experience when he was a negotiator at Oregon State. And he talked about the difference between the open process with the graduate students, and this is in the record, versus the closed session with the police department, the university police department. And he talked about how hard it was to get an agreement with the graduate students because of the open nature of it, the snapping of the fingers and the grandstanding and all those kinds of things. So when you look at and the court did find, the trial court did find, and the Court of Appeals properly applied a two-part analysis to the trial court's review, or the trial court's decision. One, it applied the clearly erroneous test to the findings of fact, and then it applied a de novo review to the balancing test. And so when you're looking at the balancing test, you have to look at, we agree, it's very, very fact specific. What's the type of document being requested? What are the harms being argued? Can they be, in this case, can the harms be remedied by, what's the interest of the public? Here, the interest of the public, according to the trial court, is advocacy, transparency, and accountability. And the trial court finds that those interests can be addressed by the public process, by at least two public hearings of the MOU before the council approves it. And then the trial court also points to the fact that these aren't draft MOUs, they're tentative agreements. And they're tentative because they're not final until they're incorporated into the MOU that's going to go to the council. And the tentative agreements, and this is in the record, are not final until they're final. In other words, you can agree on one tentative agreement, and then down the road, if there's another agreement, that could reopen the first tentative agreement.
Can I ask you a question?
I was just going to ask, what about the fact, though, to opposing counsel's point, that you don't know these draft MOUs play a significant role because otherwise you don't know what the government is giving up? Could you respond to that point?
Well, you're talking about the tentative agreements. You do know what they're giving up because at the end, when the MOU comes out, that's the document. That's what we're giving up. And so the whole notion, by the way, that of the harms that the city's arguing here, the politicization, the collusion, the grandstanding, those aren't novel ideas. There's a whole litany of cases that we cite in our brief out of state that talk about the necessity of confidentiality in negotiations. And in fact, there's one case in the Central District of California, Lockyer, that says for bargaining to work, the parties must be able to formulate positions and devise strategies without fear of exposure. And then it goes on to say the necessity of this is so self-evident as it's never been really addressed.
Do you have any cases that or other authorities that say that those same considerations exist after the MOU has been finalized?
I think it's unique. I think, Your Honor, no, because it's unique to the Phoenix process. And that's where this case, and Justice Pollack makes a point. If the court reviews this case and determines that the proper standard of review was applied, it's done because the court's order releases those TAs, those tentative agreements by default. I mean, they're out because of that limited deadline of until the next go-round of negotiations. In this particular case, by the way, this particular go-round was a unique situation because it was a one-year cycle. Typically, they're two-year cycles. And as is pointed out in the record by the testimony, is that the reason they're withheld until that next cycle is because oftentimes they're literally recycled. The TAs are recycled. If they aren't agreed to in one set of negotiations, they might be open to the next. And so the city's never said they should be completely withheld forever. You know, we understand the Scientology case. You can't hold things forever. So the reasonable conclusion, and what the trial court did, was say, okay, we'll hold it in confidence until the next cycle is over, and then they're released. And so the public, the court's correct, the public does have the absolute ability to look at what was done at prior negotiations. But again, the trial court specifically found that those tentative agreements aren't final. They aren't statements of policy. They aren't commitments of money. They are simply tentative agreements until they're incorporated into the MOU, the red line type MOU that goes in front of the Phoenix City Council. And these are real harms, by the way, that the testimony by the city's witnesses talked about. And it's not just inconvenience. It's not just it makes it harder to reach agreement, but that collusion turns into taxpayer dollars, the cost of the taxpayers. Politicization, undue pressure, grandstanding, undue pressure by the members of the union, for instance.
One of the questions that I asked opposing counsel was if there's anything in the MOUs or city code that prevents, in this case, like plea, voluntarily turning over all of those documents to, say, another union to use.
There is, because the parties sign confidentiality agreements as part of the process. So it's not necessarily in city code, but it's the practice of in the plea negotiations to sign the confidentiality agreement so that they don't voluntarily collude with other unions. In fact, and I think part of the argument that the petitioner makes is, well, it's already politicized, but that doesn't mean that it won't get worse. And I think that's one of the harms that the city brings up is that the politicization, the pressures from membership, the collusion, even though it allegedly could already happen, it gets worse when it's open to that.
That's a matter of perspective. If it's an inherently political process, as the U.S. Supreme Court has held that it is, excluding the taxpayers simply excludes one part of the political process. But be that as it may, it sounds like, and correct me if I'm wrong, you're asking for a categorical privilege for labor negotiations while they are going on. And I point you to Justice Corcoran's dissenting opinion in Phoenix newspapers where he says, this stuff really belongs in the legislature. Since then, the legislature has done a lot in this area. If we were to look at it in its entirety, we might refer to it as a comprehensive statutory scheme, but it has not done that. It has not created, whereas it has created a number of defenses, it has not created a defense with regard to labor negotiations. Isn't that a big step for us to take to conclude?
Well, no, you are, because that's not what we're asking for, okay. a categorical exception for labor negotiations. We're talking about the City of Phoenix process here, and the City of Phoenix, by its own legislative body, has created a blackout period. So there is an intentional effort by the legislative body of the City of Phoenix to keep things confidential. We're not asking the court to create a category. We're asking for the court to do is look at what the trial court did and what the Court of Appeals did and say, were the findings of fact clearly erroneous? And we would argue no. And then did the trial court and the Court of Appeals properly apply, the Court of Appeals by way of de novo review, apply this balancing test? And the Court of Appeals did apply, took a new look or a look at what the trial court did and said, and agreed with it. It found that the city has a strong interest, and the Court of Appeals agreed with that. And the Court of Appeals looked at the balancing that the trial court did, and it said that the city's interests were specific, particularized, that the witnesses were persuasive and relevant, their testimony, and that the petitioner, that the institute, had a generalized interest. All the evidence showed at the trial was that the institute had a generalized interest in accountability, transparency, and the one other, I can't remember. But the trial court said, but those things those concerns can be addressed by way of the public process. And by the way, even though the Supreme Court found that union negotiations are inherently political, in the Federal District Court of Colorado, and we cite this in our brief, in this pipe fitters case, it talks about that the importance and confidentiality of labor negotiations is recognized by Congress through FOIA. So even though it's inherently political, the federal law recognizes that labor negotiations are.
But ours does not, and to me, that weakens your position, not strengthens it.
But I think, but the point is that these aren't novel concepts when we're talking about the particular facts of the case here. That the need for confidentiality in labor negotiations, as well as other negotiations, is important for the government entity to get the best deal that it could get, not just for its own convenience or its own administrative purposes, but the best deal for its residents and taxpayers. And the trial court, in the record, makes that, on its decision, makes that finding. It acknowledges that the best interest of the state isn't just as to the convenience or the administrative satisfaction of the government body. It makes the court specifically says it's also looking at the broader interest of the city of Phoenix residents. Now, we would disagree with the ACLU position that you have to look at the statewide interest of the residents, because, again, we point out in our briefing, if it's city of Phoenix, that's one thing. What if it's Lake Havasu City? Does Lake Havasu City have to weigh its interest against the statewide interest of disclosure?
Well, and Council, let me interrupt on that point, because I don't know we have any case law that really directs us to look that broadly on that. But the question that I want to ask you is, we're saying that having confidential negotiations is important in this whole process, and I think that's the argument that the city is making for the entire labor negotiation. But the Phoenix City Code requires an initial MOU by the bargaining unit to be filed on or before December 1st of any year, and that there's supposed to be a public hearing on that. And I see that, and it sort of vitiates the argument that, well, we can't have any of this information out there. And then subsequent to that, the city's negotiator is supposed to respond and file that as well, and that's a public record too. So I'm having a hard time making a distinction between these initial bargaining positions that are public records that are supposed to be open for discussion, and then the subsequent meat and potatoes negotiation. Because if you're going to make that distinction, okay, maybe, but I'm having a hard time seeing it as a whole when these first opening rounds are supposed to be provided to the public, and in this case, they weren't.
Well, and I don't think we'd be here had plea actually filed. It's a shot across the bow MOU on that December 1st date, because that's their initial proposal. And the need for the confidentiality of the tentative agreements is exactly to protect the negotiation process from getting bogged down, from impasse being reached, from labor unrest, from pressure from members of the union, from pressure from the special interest parties, frankly, that may be pressuring from those kinds of things during the process of the negotiation. So when the initial MOU draft is submitted by plea on December 1st and the city responds, that's outside of the sausage making negotiations that occur, and that's where the concern is that that if these are made public during the process, it bogs down that very short time frame.
Well, let me ask you a question, because at least with respect to the MOUs that haven't been disclosed yet, why can't a court order that at least the initial MOUs be disclosed as they should have been?
The court did order, actually, and the trial court's decision was that at the time where the subsequent MOU was passed, that the confidentiality no longer applies, and they should have been released. And frankly, they would have been released, but for these appeals and then this petition for review.
Well, what kept the city from doing that?
I really couldn't tell you, Your Honor, other than we're in the midst of litigation. And so
if it was to comply with the city's own code, and it would have been consistent with the court.
I'm not sure it would comply with the city code, because city code doesn't address the...
Well, I guess what I'm saying is that the argument that all of these negotiations should be confidential when the Phoenix City Code itself contemplates that at least the opening round is going to be public, and then subsequent to that say, well, if you're going to continue to litigate this, Goldwater, you're getting nothing.
Well, I think that the whole purpose of this is that if you don't reach agreement in that really shortened time frame, it results in impasse. And when you have impasse, then costs increase, time demands increase, your the decision is really left up to labor relations board, so you have less control over ultimately what the negotiated decision is going to be. So we all know that, when if you don't settle a case and you let a board or a judge decide, you don't know what you're going to get. And so you may not get the deal that you want. You're going to get a deal that the labor relations board tells you you're going to have. And so that's the concern. And again, those aren't novel ideas or novel concepts. Those are real world, because a number of other cases that we cite in our brief, a New Hampshire case that talks about the need for confidentiality because of grandstanding concerns.
But we also have a declaration from Mr. Shoplock in the record that responds to all of these points.
Well, you do have his testimony, and the trial court really didn't find that his testimony was all that relevant or convincing. The fact that he's a labor negotiator for a 53-person union and comparing it to the Phoenix process, where not only you have a 2,200-person police union, and he's a fire union, you also have 4 of the unions simultaneously negotiating. So to sort of say that his experience is the same as what you see in Phoenix is like saying somebody played Little League Baseball has the same experience as somebody who played Major League Baseball. It's just not the same. I mean, in fundamental concept it might be, but in practical reality, the trial court didn't find his testimony convincing at all. And it didn't find convincing at all, and you read in the judge's opinion, you didn't find that the expert witness for Goldwater was all that convincing either, because he had no experience in either the Phoenix process. It didn't understand, couldn't even define what labor unrest was unless he looked it up on Google and thought it meant strike. So at this point, I have a minute left. Last time I was here, I tried to reserve, and you asked me why. So I think I'm just going with about the same amount of time. So I think I'm just going to go for it and tell the court that the petitioner looks at the first Board of Regents case and points to past actual experience and then predicts the future. We have 2 witnesses, and the fire union witness, Willingham, also testified that based on his experience in meeting with other union negotiators across the country, that the open process was much more difficult, resulted in much more impasse, resulted in much more politicization, much more membership pressures. So you do have actual testimony from people who have the experience, who can point to past experience to predict future. And that's exactly what the petition argues should be done, and that's what we've done. So with that, unless there's any more questions, I will rest.
Thank you. Okay, Mr. Jackson.
I'll start there quickly. So the testimony from the city's negotiator, that was based, again, on an Oregon situation involving a student union. And that negotiation was not open to the public. It was only open to members of the union. And there was testimony about grandstanding. That was rebutted by Goldwater's expert, who said grandstanding is an inherent part of the negotiation process. The second witness, Mr. Willingham, his testimony was not based on personal experience. It was based on hearsay. It was based on other people's experience. The city says that these aren't novel concepts. If they weren't novel concepts, the city should have been able to point to analogous disclosure anywhere else, and they couldn't do it. They couldn't point to a situation where records exchanged during the process were disclosed, and there were all these, parade of horribles that occurred. And Goldwater provided Mr. Shoplock as a direct rebuttal witness on that point. And this is the one piece where the trial court did clearly err. The trial court's opinion is not consistent in its treatment of Mr. Shoplock's testimony, and he was discounted partially on the size difference, but at one point the trial court says he had no experience personally negotiating, and that's not true. It's in the record, and the trial court opinion is not consistent on that. Thank you.
Thank you. Thank you. Thanks both all counsel for your argument today, and your briefing on the matter will take under advisement and issue an opinion in due course. We stand adjourned for the day.